Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 148 proceedings. The issue before the Mumbai ITAT F bench in the present case was that if the assessee has not filed his income tax return under section 139 and the assessee also fails to file the return under section 148 and also didn't comply with the assessment proceedings under section 147 and assessee comes first time before the CIT appeal that he has sold some property and he has purchased some property on which he is entitled to claim section 54 exemption. So whether the assessee has a right to do so and whether the CIT appeal is obliged to give this benefit to the assessee even if the assessee has not filed her return of income. In the present case, this issue has been taken up by Mumbai ITAT F bench in the case of Seema Heera versus Assistant Commissioner of Income Tax OSD International Taxation, and this case is reported in 120 ITR Tribunal at page number 741. The date of the judgment is 10th July 2024. The facts of the case are like this. In the present case, the assessment year is 10/11 and the assessee is a non-resident. The assessee has sold a immovable property in the financial year ending 31st March 2010. In that year, when the property was sold, that property was long-term and long-term capital gain has arisen to the assessee, and consequently she has purchased some property and she was entitled to section 54 exemption if she had filed a return of income. But she didn't file a return of income. The notice under section 148 was issued upon the receipt of information and the assessing officer issued the notice to the assessee under section 148. The assessee at this junction also didn't file the return of income in response to the notice under section 148 and even didn't comply with the various notices given by the AO. Accordingly, the ex-parte assessment was done. When the assessee filed the appeal before the CIT appeal, the assessee submitted its computation of income and all the documents relating to the sale of the property, related to the accrual of the long-term capital gain to the assessee, and consequently the detail of the purchase of the property on which the assessee was claiming section 54 exemption. The CIT appeal also sought the remand report from the AO and the AO was also aware of all these facts. But the CIT appeal didn't give relief to the assessee on the sole ground that the assessee has not filed the return of income under section 139 and she has also not filed the return in response to the notice under section 148. So she is not entitled to claim section 54 exemption. So the CIT appeal accordingly upheld the order of the assessing officer. When the matter was heard by the tribunal said that in the present case, the CIT appeal and the AO was well aware. The CIT appeal was aware at the time of appellate proceedings and the AO at the time of remand report was aware of all these facts that the assessee has accrued some long-term capital gain and the assessee has invested into the new property on which he is entitled to claim section 54 exemption, and the tribunal said that in the present case the benefit cannot be denied to the assessee on the technical ground, and article 265 comes for the help of the assessee because article 265 of the Constitution of India says that no tax can be levied or collected from the assessee without the authority of the law. The tribunal also reminded of section 119A of the Income Tax Act, which talks about the citizen charter, according to which the amount due to the assessee can be taken as a tax only as per the law. The authorities are accountable for their actions and the taxpayer is also obliged to fulfill his compliances and obligations. So according to the tribunal, this exemption should not be denied to the assessee and the AO was directed to give the exemption to the assessee. At the end of this video, once again, I am repeating the name of the case. The name of the case is Seema Heera versus Assistant Commissioner of Income Tax, OSD, International Taxation. And this case is reported in 120 ITR Tribunal at page number 741. And the date of the judgment is 10th July 2024. Thank you, friends.